Now that we've got our attendance done, Miss Moore, I understand that the parties went to mediation yesterday. How are we to proceed this morning?
Judge, we have a mediated settlement agreement with regard to the mother. Obviously, neither of the fathers appeared. They were served by posting, but they have made no appearances in this case. And so the mediated settlement agreement could not cover the fathers and did not cover the fathers. But we have reached an agreement with regard to the mother, and then we will need to do a little quick prove up on the fathers.
All right, so we're going to prove up the MSA with regard to Ms. Reyes's rights moving forward. And then when you say prove up on the fathers, what are you seeking?
Well, I'm seeking termination on both Austin Strickland and the unknown father.
All right, thank you. Ms. Mendoza, are you in agreement with proceeding on the MSA and then the case with regard to the unknown and Mr. Strickland?
Yes, Your Honor.
And Mr. Butler, I don't know if you attended the MSA since your clients were not there, but are you in agreement with proceeding in that manner?
That's fine to proceed in that manner, Your Honor.
All right, and Ms. Goodman?
Judge, I'm in agreement in proceeding with the MSA and termination of Mr. Strickland's rights and the unknown father.
All right, thank you. So what I would like to do then is I'll swear in my witnesses. I would appreciate, Ms. Moore, if you would give me a quick rundown of the MSA since it was done so late yesterday. I don't think that it's in the file yet. I did get a copy sent to me, so I am somewhat familiar with it. And I did make note that everybody signed the MSA that was present. So if you could give the rundown of the terms of the MSA, and then we'll call witnesses as to best interest and then move on to the witnesses with regard to the father's rights.
Certainly.
Can I have all my witnesses raise your right hand, please? And either Mr. Pitts or Ms. Pitts will likely have to, since you signed the agreement, there you go. Do you and each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, everybody indicated they would. Ms. Moore, you may proceed.
Thank you, Your Honor. So the agreement is, Your Honor, that the Pitts will be named permanent managing conservator of NOAA. They will be the individuals also as joint managing conservators who will determine his primary residence within either Tom Green or any of the contiguous counties. Ms. Reyes, the mother, will be named as a possessory conservator of the child. She will have visitation essentially by agreement of the parties. I think they've worked together very well so far. So the visitation will be at a location that's chosen by one or both of the Pitts in the county of the child's residence. And for the first 2 months, this month, February 2023 and March of 2023, visitation will be for 2 hours a week, supervised by either Mr. and Mrs. Pitts or a designee. Then starting in April, from April through September of 2023, visitation will be for 4 hours per week. Again, supervised by one of the Pitts or a designee. Starting in October of 2023, going through March of, or up to March of 2024, Ms. Reyes will have unsupervised daytime visitation, 8 hours per visit. Then beginning in March of 2024, so March, April, May, and June of 2024, she will have unsupervised visitation 1 time per week in the home of and supervised by Ms. Reyes, the grandmother that she lives with. The day and time of visit will be coordinated. I think the testimony or in mediation, we determined that Mrs. Pitts, Courtney Pitts, is the one who pretty much does the scheduling. Then beginning in July of 2024, assuming and upon proof of there being adequate housing, that the mother's in compliance with her MHMR services, and upon proof, if requested, of a clean or negative drug test, the mother will have a standard possession order for the child. If mom cannot provide provide proof of adequate housing, appropriate housing, or we can't determine that she's in compliance with MHMR, then visitation will remain in the home of the grandmother, Mary Reyes, I apologize. As far as visitation goes, the Pitts will give the mother 48 hours prior notice of a visit, and Ms. Reyes will give 24 hours notice of whether she intends to be at the visitation. Ms. Reyes, as part of the agreement, will remain enrolled in and at MHMR services until she's successfully discharged. It's part of the agreement that she'll take all of her medications as prescribed. She will sign some kind of release so that the Pitts can receive confirmation of her MHMR compliance. That doesn't mean that they'll be able to get all of her records from MHMR. It's just so that they can determine whether or not she's in compliance with her services. So it's almost like an attendance form or something to show that she's been doing what she's supposed to do. She will advise the Pitts of any inpatient mental health treatment by phone within 24 hours of the time that she is admitted, just so that they will know where she is, and if that was going to interfere with some kind of visit or something, that they'll have notice. If she fails to comply with her MHMR services, the visitation essentially reverts back to the beginning, where it'll be 2 hours per week, supervised by either the Pitts or a designee, until she's re-enrolled in and back in compliance with her services. As far as substances, she will refrain from using any illegal substances. The Pitts may request a drug test at their expense. Upon notice, Ms. Reyes will have 24 hours to complete the test. Failure to take the test will be deemed to be a positive test. And if there is a positive test, then she is responsible for reimbursing the Pitts for the drug testing. If she tests positive for any illegal substance, the visitation will revert back to the 2 hours of supervised visitation until she can again prove clean or provide clean drug testing. And she will execute a release so that the Pitts will have access to her drug test results. Further, the Pitts have the ability to suspend a visit if they determine that she's either under the influence of an illegal substance or that she's experiencing a mental health episode of some kind, and they determine that visitation is not in the child's best interest. Then there is child support that would be for $225 per month, beginning April 1st of this year. And the Pitts are going to be the ones who provide health insurance, and the mother will not be required to pay any medical support.
And before we move on to the best interest, Ms. Mendoza, is that your understanding of the mediated settlement agreement?
It is, Your Honor.
And did your client voluntarily participate in that mediation?
Yes, Your Honor.
Did you have any concerns about your client's ability to understand, comprehend, or interact with you during that mediation?
No, Your Honor. We were, I was present with her, explained the whole process to her, along with a mediator, and I believe she understood.
All right, thank you, ma'am. Ms. Goodman, is that your understanding of the mediated settlement agreement?
It is, Your Honor, and I think it's in the best interest of Noah.
And at any time during that agreement, did you have any concerns that any party failed to understand what was going on or lacked competency to enter into that agreement.
No, Your Honor, I think everybody fully understood it was a long mediation, so I think the mediator thoroughly went through the agreement with both or all parties, and everybody, to my knowledge, initialed each page and signed it.
All right, thank you. Mr. Pitts,
Yes, ma'am.
you were a party to the mediated settlement agreement and didn't have to be, and you are unrepresented today. Are you comfortable with moving forward without an attorney?
Yes, ma'am.
And what Ms. Moore recited on the record is that the agreement you and your wife made in that mediation.
Yes, ma'am, it is.
All right, thank you, sir. In that case, I will accept the mediated settlement agreement, having heard no legal reasons not to accept it. And the terms thereof, and we'll take some evidence on the best interest. Can Ms. Moore, you can call your first witness, please.
I'll call Ms. Ruiz. Good morning, Ms. Ruiz. What is your connection to Noah?
I am his caseworker.
Okay, and you've been working with him for a significant period of time, is that correct?
Yes, ma'am.
Okay. One of the reasons that, well, let me ask you, do you believe that the mediated settlement agreement that we reached late yesterday is in his best interest?
Yes, ma'am, I do.
Okay. One of the things that we discussed is the fact that the department didn't feel as strongly about termination in this case as in some others, because there's a bond that is developed and is ongoing between Noah and his mother. Is that correct?
Yes, that's correct.
Okay. And so the department has identified and does affirm that bond and believe that that needs to be maintained.
Yes, ma'am.
Okay, this mediated settlement agreement then provides that opportunity for Ms. Reyes and for Noah to continue that bond and for it to grow over time. Is that right?
That is correct.
Okay. Do you believe that the settlement agreement also, though, provides protection for Noah if, something unforeseen was to happen?
Yes.
Okay. And again, you believe that considering all of the circumstances of this case, that it's in Noah's best interest?
Yes, ma'am, I do.
Right. The placement that he's in the pits, he's developed a bond with them as well?
Yes.
Okay. And does it appear to you that the Pitts and Ms. Reyes work together pretty well for Noah?
Yes.
And that they can be a support system for her, as well as whatever family and outside resources she may have?
Yes.
Okay. So essentially, this is good for all of the parties involved.
Yes, ma'am, it is.
Okay. I'll pass the witness.
Ms. Mendoza, any questions for this witness on best interest?
No, Your Honor, no questions.
Mr. Butler
No, Your Honor.
and Ms. Goodman?
No questions, Your Honor.
All right, thank you. Ms. Moore, any further witnesses on best interest?
I'll just call Mr. Pitts very quickly.
Thank-
Since you're up at the top of the screen and you've already testified, do you believe that this settlement agreement is in Noah's best interest?
Yes, ma'am.
Okay. And you recognize the bond that has existed and still exists between Noah and his mother. Is that right?
Yes, ma'am.
Okay. And there's a bond between you and your wife and Noah as well?
Yes, ma'am, there is.
Oh, okay. So do you believe that this allows the bond with his mother to continue and strengthen, but also provides a safety net, so to speak, if anything unforeseen happens?
Yes, ma'am.
Okay. I'll pass the witness.
Ms. Mendoza, any questions for this witness?
No, Your Honor. Thank you.
Mr. Butler,
No, Your Honor.
Ms. Goodman?
No questions, Your Honor.
Thank you. Ms. Moore, any further witnesses on best interest?
No further witnesses on best interest.
All right, thank you. Then with regard to the mediated settlement agreement, I will name the Pitts, Courtney and Daniel Pitts, and the mother Gabrielle Reyes as joint managing conservators over Noah Reyes. The
Judge, I'm sorry, I hate to interrupt, but the Pitts are the unless I misspoke, the Pitts are the sole managing conservators, or the Pitts are the joint managing conservators together, and the mother is a possessory only.
Yes, ma'am, that is
Okay,
what I was saying.
I'm sorry.
I will name the Pitts and Miss Reyes as joint managing conservators. Miss Reyes is, I'm sorry, Courtney and Daniel Pitts as joint managing conservators with the mother Gabrielle Reyes, who is the possessory conservator. She will be ordered to pay $225 a month in child support beginning on April 1st of 2022. The visitation is by agreement chosen by the managing conservators in the county of the child's residence. If there is no agreement, there is a step-up plan that involves going from 2 hours to 4 hours to unsupervised to a standard possession order that is, and there is a prerequisite that Miss Gabrielle Reyes maintain a safe and stable home. The visitation supervisors are the Pitts or Miss Maria Reyes. The Pitts will give 48 hours notice of when a visitation will be, and Miss Reyes, Gabrielle Reyes, will give 24 hours notice back that she will be attending that visit. There is a prerequisite that Miss Reyes maintain her mental health and sign a release to get attendance and compliance records, and provide 24 hours a notice of any, within 24 hours, notice of any inpatient treatment. There is also a prerequisite that Miss Gabrielle Reyes maintain her sobriety and not use any illegal substances. There's the ability for the Pitts to request to take a drug test, and if there is a failure to maintain the mental health or a positive or no-show drug test, the visitation reverts back to the 2 hours a week supervised. With regard to the mother's rights, I find that this is in the best interest of Noah Reyes, and I'm very happy to hear that she will continue to work on her own mental health needs and still be able to see her son and work towards even more connection with him. With regard to the second half of this trial, we'll now start on Mr. Austin Joe Strickland and the unknown father. Ms. Moore, your first witness.
First, before I do that, I would ask the court to take judicial notice of the fact that both Austin Joe Strickland and the unknown father were served with by posting pursuant to a motion that was filed and granted by the court, that the returns were filed with the court on January the 17th of 2023, but the posting happened in December of 2022. So I'd ask the court to take judicial notice of the those two service documents.
The court will take judicial notice of the fact that Austin Joe Strickland and the unknown father were served by posting that was executed in December of 2022.
I had filed an exhibit list that included 8 exhibits, but today I'm only offering exhibit number 4, which is a certified copy of the Certificate of Paternity Registry Search for Noah that indicates that no one ever signed up with the registry to claim parentage of Noah. So I'll offer this time only exhibit number 4.
Any objections, Ms. Mendoza?
No objection.
Mr. Butler?
No objection.
Ms. Goodman?
Objection, Your Honor.
That will be admitted.
And I'll call Ms. Ruiz.
You may.
Ms. Ruiz, during the pendency of this case, has there ever been a man who has in any form contacted you to say that he is Noah's father?
No, ma'am.
Okay. Specifically, has Austin Joe Strickland ever contacted you in any manner to talk to you about his who might be his son?
No, ma'am.
Okay. Did you look for and try to locate Austin Joe Strickland?
Yes, ma'am, I did.
Okay, can you tell us just briefly what you did in regard to trying to locate him?
I have asked Ms. Reyes if she has any information on his whereabouts or any contact information throughout the duration of this case. We had submitted a finders search, and we had tried contacts that were returned from that finders search via mail and phone contact. They all never came back as undelivered or with the phone contact. There was nobody that knew him or it was the wrong number. I also have searched the TDCJ inmate website to see if by any chance he may be incarcerated, but no luck there either.
Okay, all right. And obviously, was Mr. Strickland the only name that Ms. Reyes brought forward as far as a specific individual?
Yes, ma'am.
Okay. So other than Austin Joe Strickland, I mean, it might be him, it might be the unknown father, but we don't know. Is that right?
Correct.
Okay, but since the time of posting specifically, has anyone, either Mr. Strickland or anybody else, come forward and claimed parentage or contacted you in any way with regard to Noah?
No, ma'am.
Okay. Do you believe then that based on that, that it would be in Noah's best interest for the parental rights of Austin Joe Strickland and an unknown father? Do you believe it would be in his best interest for those rights to be terminated?
Yes, ma'am.
Okay. And presumably Mr. Pitts is pretty much the only daddy that Noah knows. Is that right?
Yes, ma'am.
Okay. I'll pass the witness.
Check the local county jail records in Tom Green County for any for Strickland.
I do check them daily to see if there's any person that we are in search of. I never seen him on our email daily. No, sir, I never had any information that he was in Tom Green County.
Did you make any effort to check in any other county?
In Kerr County, we did exhaust our efforts in Kerr County. That was around the last area that he was maybe known to be.
Okay, and what was the result there?
No, sir, we didn't have any information that led to his location.
Okay, and did you check with the federal government to see if they have him in custody, the federal inmate locator?
I checked the TDCJ inmate. I did not check the federal unless it's the same one. I'm not sure.
Your Honor, if I can have just a moment, I'm checking that now.
Yes, sir.
Your Honor, just for the record, I just checked the Federal Bureau of Prisons inmate locator. He does not show up on that. I also checked on VineLink, which hits the majority of the county jails in the state of Texas, and he did not show up on that. With that, no further questions.
All right, thank you, sir. Ms. Goodman, any questions?
No questions. Your
Ms. Moore, anything further for this witness?
Not for this witness, Your Honor.
Your next witness?
I'll call Mr. Pitts again.
Thank you.
And put you through it today, Mr. Pitts. With regard to these the unknown father and Austin Joe Strickland, do you believe that it would be in Noah's best interest for the parental rights of these two people to be terminated?
Yes, ma'am.
Okay. I'm going to assume, I haven't seen you and Noah together, but I assume that he calls you daddy?
Yes, ma'am, he does.
Okay. And there's nobody else that he calls daddy?
No, ma'am. Not that I'm
Okay.
aware of.
Okay. All right. And you're not aware of any other individual that could potentially be Noah's biological father?
No, ma'am, I'm not.
Okay. So you and Noah have a father-son bond, and do you believe it would be in his best interest for these other individuals to be terminated?
Yes, ma'am.
Okay. I'll pass to the department, Russ.
All right. Ms. Mendoza?
No witnesses, Your Honor, I rest.
And throughout the trial, for the whole trial, are you resting at this time?
Yes, Your Honor.
All right, Mr. Butler.
We would rest, Your Honor, request a brief closing.
All right, thank you, sir. Ms. Goodman,
No,
any witnesses?
sorry. No further evidence, Your Honor, on my behalf, or in Noah's behalf. And I would rest as well.
All right, thank you, ma'am. At this time, since all of the evidence is in and the parties have rested, can I hear from CASA, please?
Yes, ma'am. CASA feels that the best place for Noah is with the Pitts. We do recognize that Gabby and Noah have a relationship, and we recognize that they do need to keep that relationship, but we are very hopeful that the Pitts can continue to help Gabby and Noah build that relationship and help Gabby with her mental health and move forward safely with Noah. Thank you.
Thank you, ma'am. At this time, I'll take closing arguments. Ms. Moore?
Just that I would ask the court to terminate the parental rights of Austin Joe Strickland and the unknown father based on the totality of the circumstances and the evidence presented.
Thank you. Ms. Mendoza, any closing remarks?
I waive closing, Your Honor.
Thank you. Mr. Butler?
Yes, Your Honor. While I don't have a client available to find out their desire on this, I would submit to the court it's not in the child's best interest to terminate Mr. Strickland or the unknown father, since the mother is not being terminated. That would allow them the opportunity of, at some point in the future, they came forward to join into a custody case with regard to the child and possibly start a relationship with the child. It would leave that possibility open for them to do that. A termination pretty well takes them out of that. And if you're not terminating mom, why terminate dad? Thank you.
Thank you, sir. Ms. Goodman, any closing remarks?
I join with CPS in asking the court to terminate the parental rights of Austin Strickland and the unknown father. I think an exhaustive search has been made to locate the father of Noah, and nobody has come forward. And I think that for stability purposes for Noah, it would be best if those parental rights were terminated. Mr. and Mrs. Pitts have done an excellent job with Noah. He identifies them as parents, identifies Mr. Pitts as his father. And I think it just leaves it open for instability in Noah's future to not terminate those father's rights. I do believe that the mediated settlement agreement, all parties participated. I believe that it's in the best interest of Noah. He has been thriving with the Pitts, and I too agree that Ms. Reyes and Noah have a bond, and I hope, as CASA does, that that continues, and that the Pitts and Ms. Reyes can work together as they have been doing for the best interest of Noah, and to support him and help him grow in a good environment. So I, on behalf of Noah, would ask for the termination of the parental rights and the approval of the mediated settlement agreement.
And Your Honor, if I may, just so the record's clear, she indicated that all parties participated in the mediated settlement agreement. My clients did not, because I don't know where my clients are to have them participate.
All right, thank you, Mr. Butler. I will make note of that. At this time, I find that the court has jurisdiction to hear the case, that the parents were served. That includes Ms. Reyes, Mr. Strickland, and the unknown father, and notice was given of the final hearing. As was stated earlier, I have already approved the mediated settlement agreement and the terms regarding Courtney and Daniel Pitts with the mother Gabrielle Reyes and Noah Reyes. With regard to Austin Joe Strickland, I will take judicial notice of the fact that the original petition was filed on September 23rd, 2021. There is nothing in the record that indicates any response from any potential fathers. There's no answer. There is no letters saying that they are claiming paternity in the file. I'll further take notice of the motion for alternative service filed by the department on November the 2nd, 2022, and the affidavit contained to that motion which sets out at that time the diligent efforts by the department to locate any father. I have admitted the paternity registry as petitioner's exhibit 4. On that paternity registry, there is no man listed and no one who has claimed paternity of the child Noah Reyes. Based upon those factors, I find that it is in the best interest, that grounds exist, and it is in the best interest to terminate the rights of the alleged biological father, Austin Joe Strickland, and the unknown father at this time, that after being served with citation, neither filed a timely answer or response. And the child was under 1 year of age at the time the petition for termination of the parent-child relationship was filed, and they have not registered with the paternity registry. I find that the department did submit the evidence of the paternity registry and has provided adequate evidence of the diligent search by the department, and having done so, then and hearing the evidence, it is appropriate to terminate the rights of Austin Joe Strickland to Noah Reyes and the unknown father to Noah Reyes. That being said, and having dealt with Miss Gabrielle Reyes' rights and the unknown and Austin Joe Strickland's rights, I will remove the department as the temporary managing conservator, having named the Pitts and Miss Reyes as managing and possessory conservators. I will discharge Miss Mendoza as the attorney for Gabrielle Reyes for good cause, and thank you very much for your advocacy on her behalf. I will discharge Mr. Butler as the attorney for Austin Joe Strickland and the unknown father. Thank you for your work on that. And Miss Goodman, since we are not having any more hearings on this, I'm going to have to discharge you as the attorney ad litem for Noah Reyes for good cause. Thank you for your representation in this case. So that means moving forward, it's Miss Gabby here and the Pitts, and I wish you all the luck in the world. I am very happy to hear that this family that was created is able to continue on and work together. I'm very happy that I know that the mediation yesterday was like 8 hours long, 9 hours long. It was very long. So I do appreciate everybody's serious contemplation about truly what is in the best interest of the child here. And I do believe that the result of today's hearing is what's in Noah's best interest. We'll ask Ms. Moore if you will draft that final order. I do believe that you can do it all in one order, naming the Pitts as joint managing conservators, Ms. Reyes as a possessory, and then including the termination grounds.
I will, Your Honor.
Should Mr. Austin Joe Strickland show back up, Mr. Butler, and request an appeal, he has a right to appeal, and this is for Ms. Reese as well. If you receive any information from Mr. Strickland after today's hearing that he wishes to appeal this hearing, then he has a right to do so. It's a very limited right in that he has a very short time to do that appeal. So please let the court know as soon as possible if you were to hear from someone claiming to be Mr. Strickland.
I will, Your Honor.
Thank you, sir. Any questions or clarifications, Ms. Moore?
No, Your Honor.
Ms. Mendoza?
No, Your Honor.
Mr. Butler?
No, Your Honor.
Ms. Goodman?
No, Your Honor.
All right, then I wish the parties all the luck in the world.